7 seconds after the story broke, something almost invisible to the untrained eye changed the entire investigation. A small, shallow depression at the edge of a yard. What looked like a minor disturbance in the earth is now being treated by investigators as a possible turning point, a place where ordinary fragments and traces, when examined with modern science, could point to answers a community has been praying for. This isn't clickbait. It's procedure. It's the slow, careful work of turning tiny physical clues into testable facts. If you want follow-up coverage explained in plain language, subscribe now, tap the bell, and drop your thoughts in the comments below. Tell us which forensic step you want us to unpack next: DNA testing, soil matching, or search warrant procedure, and we'll break it down in the next post. At first glance, the scene was modest. A shallow gouge in the dirt, some disturbed soil, a few items collected and labeled as objects of interest. That cautious phrase is deliberate. Investigators use it because they must avoid overstating the significance of preliminary finds. Yet what the public should understand is that objects of interest is the starting point of a chain. A single thread, a piece of plastic, a smear that tests presumptively positive for biological material, each item on its own could mean very little. Together, though, when placed in a controlled evidentiary framework, they can point investigators to a location, tie a suspect to a tool, or link a missing child to a site. That's the hope here, that meticulous forensics can turn fragments into direction, and direction into recovery and identification. The first rule at any scene is documentation. When investigators located the depression near the Harrow family property, they photographed it from multiple angles, used scale markers so later analysis can measure depth and position, and created a full digital record. Every item removed from that shallow depression was placed in a separate sealed bag, labeled, and logged into a chain of custody ledger. Those steps feel bureaucratic, but they are the legal backbone of any forensic result. If a lab later returns a match, a DNA profile, or a fiber analysis, defense counsel will examine the chain of custody as one of their primary challenges. Breaks in documentation open the door to questions about contamination, tampering, or mislabeling. So the unglamorous work of paperwork is actually what makes a discovery admissible and persuasive in court. So what kinds of tests do investigators typically run on items taken from a depression like this, and why do they matter? First, field teams perform presumptive tests for biological material. These tests are quick indicators that something on an item might be blood or other tissue. They do not prove anything on their own. A positive presumptive result triggers laboratory analysis. In a laboratory setting, technicians extract DNA, run STR profiling when nuclear DNA is available, and turn small, degraded fragments into genetic signatures that can be compared to known reference samples. For a missing child case, those reference samples can include medical records, pediatric dental records, or cheek swabs from immediate family members. If DNA from an item is consistent with the missing child's profile, that is a pivotal piece of evidence. If it matches a parent, that provides a different but equally important kind of information about contact and transfer. Trace evidence is another powerful field. A single fiber holds a surprising amount of information. Analysts examine fiber composition, cotton, polyester, acrylic, and the microscopic where patterns, dye composition, and thread count. When investigators can link a recovered fiber to a blanket, a piece of clothing, or a crib sheet known to belong to a child, they do not claim that the fiber proves where a person was buried. Instead, they use that fiber as one element in a broader mosaic. If a child's blanket fiber appears in soil from a depression and that same soil matches a second location through geochemical fingerprinting, investigators begin to form a directional hypothesis. Items associated with the child were present at this place, and the soil signature connects that place to another parcel of land that warrants closer examination. Tool marks and footwear impressions tell a related story. A shovel leaves a pattern of wear. A spade's blade has individual striations. Toolmark examiners compare the striations on a seized implement with the impressions seen in disturbed soil. If a particular shovel from a suspect residence bears soil similar to the soil in the depression, and if the tool's markings match the disturbance pattern, that moves the inquiry from speculative to probative. Footwear impressions add a human dynamic. Who moved through the yard, and when? A single partial print may be inconclusive, but an array of prints, analyzed and timed through overlay comparison, can tell investigators which paths were taken and which doors were likely used to move items in or out. One of the most underappreciated forensic sciences in a case like this is soil geochemistry. Soil is not uniform. It has a chemical and mineralogical fingerprint influenced by local bedrock, human activity, and microflora. Labs can run spectroscopic analyses and mineral assays that produce a complex profile, a fingerprint, for a given soil sample. When soil from a depression matches soil from another site that investigators have reason to suspect, the connection can be used to justify targeted excavations. Soil matching does not tell you what is in the ground, but it gives investigators probable cause to look somewhere else with more intensity. When soil signatures align with fiber matches and biological traces, that convergence becomes legally and scientifically significant. We often hear people ask, why didn't the initial searches find this location earlier? That's a fair question, and it gets to the human and logistical limits of search operations. Initial sweeps prioritize breadth, covering large areas quickly to find obvious signs. Follow-up searches are slower and more methodical. Weather and seasonal changes play a role. A recent rain, a windstorm, or a shift in landscaping can hide or reveal small disturbances. Different teams bring different tools and levels of attention to detail. That explains many late discoveries in long investigations. Still, from a public perspective, an overlooked site creates legitimate concerns and gives the defense an opening to attack investigative thoroughness. The burden on investigators is to show that subsequent discovery was the result of renewed diligence, not after-the-fact planting or manipulation. That is why transparency and documentation are essential. Investigators must not only collect material correctly, they must be able to demonstrate through logs, witness statements, and video that the depression was discovered in situ and that no unauthorized person had access. Surveillance footage from nearby cameras, time-stamped GPS tracks from search teams, and field notes from the officers who made the discovery all form a mosaic that either supports or undermines the initial rapport of the find. In hearings, judges and juries will examine those administrative records as closely as they examine lab results. Even with careful documentation, nothing in forensics is presented in isolation. The scientific process is cumulative and adversarial by design. Labs run controls, blanks, and repeat tests. When a presumptive test indicates the presence of biological material, independent extractions and STR profiling are performed, sometimes by separate laboratories. The defense is entitled to request independent testing. Courts accept that it strengthens the evidentiary integrity and provides a safeguard against error. In practice, that means a single lab finding rarely ends a story. It is the repetition, the cross-verification, and the concurrence of multiple lines of evidence that create a persuasive narrative. Let's walk through a hypothetical sequence investigators might pursue based on a depression with objects of interest. First, field presumptive tests are run. If any return positive indicators for biological material, samples are preserved and expedited to a DNA laboratory. At the lab, technicians attempt nuclear DNA extraction and STR profiling. If the DNA is degraded, mitochondrial DNA testing may be used to provide maternal lineage matches. Simultaneously, the lab runs fiber analysis and compares dye chemistry against known fabrics. Soil samples are analyzed for mineral and elemental composition. Tool marks are compared to seized implements. Phone data is obtained under legal process. Each element feeds the affidavit supporting a search warrant. If the combined evidence establishes probable cause, investigators obtain judicial authorization to excavate additional sites where soil signatures and digital breadcrumbs converge. Excavation is a forensic operation akin to archaeology. Forensic anthropologists and recovery teams remove soil in controlled layers, document GPS coordinates and depths, photograph everything, and preserve any finds in a manner that maintains context. If small bone fragments or teeth are recovered, Those items are cataloged and transported under strict chain of custody protocols to laboratories capable of DNA amplification from degraded samples. In parallel, forensic odontologists may compare dental records if teeth are present. Mitochondrial DNA testing from bone or tooth can establish maternal lineage. Each successful analytical step must survive cross-examination about collection, preservation, and analytical rigor. It is crucial to emphasize that even a positive DNA match or a soil link is not an automatic closing of the case. Courts and juries require a coherent narrative that explains how the evidence fits with other investigative facts, surveillance footage, witness statements, phone locations, and timelines. The defense will challenge every link. They may argue secondary transfer, that fibers moved through innocent contact, or contamination caused by investigatory error. They may question whether the soil sample could have been introduced later. Those are legitimate lines of defense, and prosecutors must be ready with corroborative evidence, video, timestamps, device records, and independent lab confirmations. Digital forensics often form the connective tissue that turns a series of scientific results into a prosecutable case. Timestamped cell site pings and GPS logs can place devices near a site at specific times. App histories and deleted messages, when recovered through proper legal processes, can show attempts to coordinate an account or to hide an activity. Search histories on devices can reveal queries related to disposal, decomposition, or foreign locations. When phone records align with physical evidence, for example, if phone pings place a parent near a location whose soil signature matches the depression, investigators gain an evidentiary pattern that is more than the sum of its parts. Those digital breadcrumbs are not standalone proof, but in combination with physical traces they significantly strengthen probable cause. From the human angle, small physical evidence can dismantle or support narratives. A parent's account that a child was taken by an unknown person will be tested against the presence of a child-associated fiber in a nearby yard and against the absence of any known perpetrator on nearby camera footage. If forensic evidence strongly links a child's property to the depression, and if investigative timelines and device records put parents in a position of control, jurors will have to weigh the plausibility of an outside abduction against the forensic facts. Defense attorneys will offer alternative explanations, transfer through innocent means, contamination, or misidentification, and the court will decide which narrative fits the totality of the evidence. Legal procedure matters deeply here. Preliminary hearings scheduled in mid-September will be the first formal forum where prosecutors may present elements of the forensic material to show probable cause. Defense counsel will file motions demanding preservation of evidence, disclosure of laboratory protocols, and the opportunity for independent testing. Judges will weigh admissibility and the reliability of methods. If the labs are still processing, prosecutors may summarize preliminary results in affidavits supporting search warrants while withholding sensitive technical details until expert testimony is ready. That interplay between discovery and motion practice often shapes whether evidence appears at trial in the form prosecutors envision or is heavily constrained by court rulings. Timing in the labs also needs to be understood by the public. Presumptive tests can produce results within hours. Extraction and STR profiling, however, depend on sample quality and laboratory backlog. A typical turnaround may be days to a week, sometimes longer. Specialized analyses like geochemical soil matches or advanced toolmark comparisons can extend beyond that, especially if outside reference databases or scarce instrumentation are required. Defense-requested independent testing adds time but contributes to the reliability of the findings. In high-profile cases, patience is difficult for families and communities, but rushing tests or shortcuts in documentation risks producing results that cannot be used in court. It's easy to drift into dramatic speculation about what a recovered item means. Responsible reporting resists that urge. The scientific and legal systems are cautious because the stakes are enormous: a child's fate, a family's reputation, and potential criminal penalties. Investigators and prosecutors know that a single compelling result, a DNA match to the missing child, a soil signature tying two sites, tool marks matching a suspect implement, has the power to change the trajectory of a case. but they also know each result must be defensible in court. That is why the chain of custody, duplicate testing, peer review, and transparent methods are not academic formalities. They are the mechanisms that allow scientific discoveries to be translated into justice. We must also acknowledge the emotional landscape surrounding this kind of discovery. For neighbors and advocates, the depression's find evokes a mix of hope and frustration. Hope that new evidence might finally provide answers, and frustration that it was not found sooner. Community members will press for transparency while sometimes pushing social media narratives that law enforcement warns can be harmful. Investigators are careful in their public communications because premature releases can contaminate evidence, create false leads, or taint jury pools. In the public square, patience is difficult to maintain. In the laboratory, patience is a requirement. If remains are recovered and positively identified through DNA or dental comparison, the legal and emotional consequences are profound. A coroner's report would document what the available evidence shows about cause and manner of death to the extent possible. Prosecution may expand or clarify charges. Defense counsel will respond with challenges and alternative explanations, and the community will be forced to reckon with a painful confirmation. If remains are not recovered, but the evidence strongly points to a location and to a suspect, prosecutors may still proceed based on circumstantial evidence and a constellation of scientific results. Either way, the evidentiary standards of the courtroom will govern how the case advances. So what should you watch for next? First, official forensic reports or prosecutor summaries that move beyond the phrase, objects of interest. Those documents will explain what tests were run, what controls were used, and what preliminary results were returned. Second, court filings around mid-September, preservation orders, search warrant affidavits, or defense motions challenging procedures will be revealing. Third, announcements about authorized excavations or expanded searches tied to soil matches or other convergent evidence. And finally, independent confirmations, when labs publish method descriptions and when forensic reports withstand the scrutiny of cross-examination at hearings. For those who want to help, the constructive route is specific. If you have verifiable information, original time-stamped photos or videos, eyewitness accounts with contact details, or physical materials that predate public awareness, provide that to investigators. Do not post unverified speculation on social media. It can derail investigations and unfairly harm people's lives. Law enforcement agencies typically maintain tip lines and secure portals for submitting evidence. Use them. In the end, what began as a small depression at the edge of a yard is now a hinge. The hope is that patient, exacting forensic work will convert that hinge into a pathway to the truth. That pathway requires time, documentation, and legal diligence. It requires labs that run controls, courts that adjudicate admissibility, and investigators who can weave scientific results into a coherent narrative. Above all, it requires restraint from those watching. A demand for verified facts and an understanding that justice is assembled piece by piece, not by headlines. If you want us to unpack any of the scientific or legal steps in detail, how STR profiling works, what soil geochemistry means, or how an affidavit for a search warrant is drafted, tell us in the comments and we'll produce a focused deep dive. Subscribe and enable notifications to follow timely explanations of lab reports and court filings as they appear. Until then, keep your focus on verified updates and documented filings. That's where answers live. Stay compassionate, stay critical, and we'll be here to help translate each new piece of evidence into plain language as the case unfolds.